Okay, let's dive right into this explainer and look at the high-stakes world of the EB-5 program. Look, if you're pursuing a U.S. green card through investment, you already know that understanding the mechanics of your petition is really only half the battle. So what happens when a sudden policy shift, like a government visa ban, just completely freezes the entire process? Well, today we're going to explore exactly how these bans intersect with the EB-5 program, what it means for your hard-earned capital, and honestly, most importantly, what it means for your family's future.
Immigration policy can feel incredibly dense, but we have a very clear roadmap today. First, we'll do a quick refresher on the EB-5 investor program, and then examine how visa bans hit processing. After that, we'll clear up the difference between backlogs versus visa bans, dive right into the key challenges for investors, and finally, wrap up with strategies to navigate risks. Let's get to it. Section 1, the EB-5 Investor Program. Created by Congress way back in 1990 to attract foreign capital, this program demands a massive financial commitment. To even participate, you typically need to commit $1,050,000. But if you invest in a targeted employment area, which is usually a rural or high unemployment zone, that threshold drops down to $800,000. It's a huge chunk of change, right? In exchange for this, foreign nationals and their immediate families become eligible for permanent U.S. residency. Historically, we've seen massive demand for this from countries like China, India, Vietnam, and South Korea, mostly due to strong economic ties.
Now, in a perfect world, this pathway is a simple, logical progression. Step 1, you make that qualifying investment, either directly into a new commercial enterprise or through designated regional center. Step 2, your investment creates or preserves at least 10 full-time jobs for U.S. workers. And finally, Step 3, you receive your green card. So basically, investment leads to job creation, which ultimately leads to your residency. Pretty straightforward, right?
Section 2, visa bans hit processing. But what happens when executive authority suddenly drops a presidential proclamation or an executive order? That perfect three-step pathway we just talked about, it completely breaks down. And there is a stark contrast here between investors who are stuck overseas versus those already inside the United States. If a visa ban targets a specific nationality, investors going through consular processing might have their consular interviews postponed indefinitely. I mean, we saw this exact thing during the COVID-19 pandemic with Presidential Proclamation 114 that suspended immigrant entry and literally froze thousands of cases globally for over a year. On the flip side, though, if an investor is already residing in the U.S. on a non-immigrant visa, like a student or work visa, they can often pursue an adjustment of status. This domestic route is largely insulated from those overseas restrictions, assuming, of course, a visa number is currently available.
Section 3, backlogs versus visa bans.
Okay, we really need to clear up a major misconception right now, because mixing these two concepts up causes a lot of unnecessary panic. Let's think about the root causes here. Visa retrogression simply means there's higher demand from a specific country than the annual visa allocation actually allows. Basically, it's just a math problem. A visa ban, however, is a sudden policy restriction. Now, the absolute key takeaway to remember is that neither of these issues cancels your underlying I-526 approval. However, while retrogression merely delays consular processing, a ban can halt it entirely, regardless of whether a visa number is actually available for you. And as we just discussed, an adjustment of status is generally unaffected by a ban if you're already in the U.S., whereas retrogression is going to delay your ability to even file.
Section 4, key challenges for investors. Let's zoom in on the heavy emotional and financial toll these delays cause for families caught in the crosshairs. Because it's not just about waiting around, it's about the very real risks that pop up during that wait. Instead of the expected 3 to 4 year timeline, a ban can result in an extended capital lock-in of 6 years or more. That puts immense pressure on your projects. Remember that 10 job creation requirement? Yeah, that has to be met and documented by the time you file to remove the conditions on your residency. If bans push back your timeline, those job records have to be maintained over a much longer period. Plus, it creates total uncertainty around fund redeployment. If your funds sit in a project longer than intended, they might actually need to be redeployed into secondary investments. And you have to be absolutely sure those new investments still satisfy all the USCIS requirements. It is a lot to juggle. And this brings us to a frankly heartbreaking reality regarding derivative beneficiaries, meaning the spouse and unmarried children under 21 of the principal investor.
Because of these ban-induced delays, children who were comfortably under 21 when the petition was filed might actually age out before the visa is finally issued. That means potentially losing their derivative status entirely. Now, the Child Status Protection Act does offer some relief, but our sources note it doesn't fully protect against aging out during really significant ban delays. And on top of that, if a spouse holds a different nationality than the main investor, they might face completely separate processing complications depending on the exact wording of the ban. So every single family member situation really requires its own individual assessment.
Section 5. Strategies to navigate risks.
So, how do we actually handle this? Let's zoom back out and look at a strategic roadmap so savvy investors can survive these unpredictable disruptions. First things first, let's address the elephant in the room. This is the absolute biggest question, the one that panics investors the second a ban hits the news. Can a visa ban cancel my approved EB-5 petition? Take a deep breath. The answer is a definitive no. Your I-526 or I-526E petition remains approved and totally intact. The approval of your petition is a completely separate determination made by USCIS. A ban simply prevents you from proceeding to the next step, which is the actual visa issuance, or your physical entry into the US, for the duration of the restriction. So your baseline approval and your legal investment are completely safe.
Okay, so knowing your petition is safe, how exactly do you take control of your situation today if you find yourself stuck in one of these holding patterns?
Well, you absolutely must work with specialized counsel. And I don't just mean any immigration attorney. You need an EB-5 specialist who really understands the nuances of redeployment and timeline extensions. Have them confirm your eligibility for a domestic adjustment of status if you were already in the U.S. Just be careful, though, because traveling outside the U.S. during a ban requires very specific advanced parole planning. Also, you need to dig in and review your investment agreements specifically for redeployment clauses. Keep a meticulous eye on your kids' ages to watch for that aging out risk. And finally, be proactive. Actively request case status updates from your project manager. A great tip from our sources, projects in targeted employment areas sometimes offer structural benefits with more conservative job creation buffers, which can literally be a lifesaver when you're dealing with timeline risks. Look, a visa ban doesn't erase your capital, and it doesn't erase your path to residency, but it absolutely changes the game. It stretches timelines, and it introduces entirely new risks. The investors who navigate this successfully, they're the ones who understand the landscape and maintain their flexibility. So I want to leave you with this final thought. Knowing that unpredictable policy shifts are just a historical reality, are you structuring your investment and your family's legal strategy today to withstand the roadblocks of tomorrow?